Wheelchair-bound Professor G N Saibaba, accused of having Maoist links, rather convicted of them till he was acquitted yesterday, and then that acquittal was stayed by the Supreme Court, continues to dominate the headlines. We'll be looking at that case closely on the broadcast this evening. I'm Barkha Dutt, you're with the Mojo Story. Our focus, as I said today, is on Delhi University Professor G N Saibaba, who is serving a life term on the accusation that he has links with dreaded Maoist groups. The Bombay High Court in the last 24 hours actually found that proper procedure had not been followed in this conviction and acquitted him. Then the state, in this case Maharashtra, and the center were on the same page. They sought an emergency hearing of the Supreme Court, and the Supreme Court decided that the Bombay High Court had not made, in fact, the correct judgment and have stayed the release. In other words, Mr. Saibaba will continue to be in jail. Now, depending on your point of view, he is either what the Solicitor General said in court today, a dreaded, in quotes, urban Naxal. But for his friends, his supporters, he is somebody who has been made a victim of a system and a draconian law. To try and find out where the truth lies, if we can, let's introduce our guests on the program today as we look at the Supreme Court's emergency meeting that reversed the decision of the Bombay High Court to acquit Professor G N Saibaba. On the program today, first up, let's bring our guest, Chitranshul Sinha. Chitranshul, of course, is a well-known advocate and rights activist as well as an author. It's good to see you, Mr. Sinha. Also joining us is lawyer Will Matthews. Mr. Matthews has in the past defended jailed journalist Siddiq Kappan. It's good to see you, Mr. Matthews. Also joining us on the program is lawyer Shashank Shekhar Jha. Mr. Jha, it's good to see you again. Also joining us is senior advocate and rights activist, Mr. Mihir Desai. Good to see you, Mr. Desai. And finally, Mr. PK Jain, who's, of course, been a veteran IPS officer from the state of Maharashtra. Mr. Desai, let me get first responses from you. I know that there was a lot of sort of hope after the Bombay High Court acquittal among the friends, family, and supporters of Mr. Saibaba. But the Supreme Court today has basically disagreed with the Bombay High Court. They have said that technicality is not reason enough to not look at what Professor Saibaba was convicted for to begin with, which is, of course, Maoist links. And finally, you have Justice Shah of the Supreme Court saying it doesn't matter if he had direct involvement in violence or not. When it comes to Maoist violence, the brain, this is Justice Shah making this quote, the brain is the most dangerous. What are your thoughts, Mr. Desai?
Well, let me at the outset declare that I had appeared for Mr. Saibaba at a bail hearing for him. I was appealing for him at an initial stage. So to that extent, my bias will be there. But I personally feel that while the Supreme Court was justified in issuing notice on the issue, namely that they want to hear the matter fully, okay, that is understandable because it goes on a technicality, etc. I feel the staying of the High Court's order was erroneous, and that should not have happened, because High Court has discussed. It's a constitutional court. It has discussed the whole issue concerning sanction, the lack of sanction or the irregularity in the sanction in a very threadbare manner. And unless that is something which is really set aside, okay, it is not. It would not be. Remember one thing: it is not correct to say that he was acquitted. He was discharged, okay, by the High Court, because acquittal is after you look at the evidence on merits.
Yes, that is an important correction that you make. But he was going to walk free. He was going to be released from jail because the Bombay High Court argued that basically procedurally, the process was not followed, and therefore his conviction was null and void. Please correct me if I'm summarizing this incorrectly. Basically, till last night he was going to be a free man.
Absolutely, you're absolutely right. Bombay High Court had said that and Bombay High Court went further and said that, look, we are talking about an act which anyway gives accused very little rights. So whatever little rights the accused has have to be treated as sacrosanct. And right to have a proper prior sanction is a sacrosanct right of the accused. And if you violate that, then the entire proceedings should be quashed, and that's what the Bombay High Court did.
And to Justice Shah's point, let me open this up now for the rest of the panel. Mr. P.K. Jain, let me bring you in now. I think that's an important distinction that Mihir Desai makes, that it's not that the Bombay High Court declared the innocence of Professor Saibaba. It simply said that procedure was not followed and therefore the conviction could not be held up. The Supreme Court has argued that that is not reason enough. The Solicitor General made a very, very passionate argument against what he called urban Naxals. And Justice Shah of the Supreme Court made a rather intriguing observation. He said the brain is more dangerous. Now, as an observation, this is fine. Can we bring up that slide, please? He said the brain is more dangerous when it comes to Maoist activities, even more than direct involvement. But when seen through the prism of law, what does this actually mean? I mean, how do you criminalize how somebody thinks? Mr. Jain.
Thank you very much.
Yeah, go ahead. Yeah, go ahead, sir.
Good evening, Barkha. Thank you very much. I think I'm the only odd man out as a policeman here. And I have my own biases too. You know, I have been in charge of the anti-Naxal operations in Maharashtra state, and I have seen it at the pan-India level also. So what I would say in this case is that the High Court has summarily decided that because the sanction was not obtained, that's why they've set the conviction aside. Whereas the trial court had gone into the merits of the case, and it is almost 5 years since the conviction was awarded to him. And the Supreme Court has also similarly gone into the prima facie into the same kind of argument that only the technicalities cannot be the reason good enough to result in acquittal or discharge of the accused, because in this case the material was there. There was adequate material to convict and prosecute G N Saibaba, and on the basis of which he was convicted and convicted for life. So, in my opinion, the brain being the most dangerous part, I fully agree with it for the simple reason that the operatives in the field, they go by certain dictates and directions of the Politburo, the topmost decision-making body of the CPI-ML. Or the Naxals. There are n number of outfits, under which these people operate. So the directions come where, how to conduct an operation. 2, 3, 4 dalams are brought together, company formations are brought together, security forces are attacked. The objective with which this entire movement started has been lost long back. Now it is the sheer extortion, the annual extortion conducted and committed by the various outfits of this movement runs into close to 1,000 crore rupees. So you can imagine that the kind of havoc there, they don't allow any development to take place in that area. And people have been operating with impunity, from the confines of their offices.
So when you hear this phrase, Mr. Jain, that the brain is more dangerous, you're thinking in terms of the mastermind of a violent attack.
Absolutely.
Not ideology.
It is both. Yeah. It is both. They see the ideology also emanates from there, and the directions of clear-cut operations also emanate from there itself. See, the Naxals operate in, or the urban Naxals operate in 3-4 different scenarios, be it agrarian, be it labor, be it students. Now the caste and religion also have been thrown in. So there are n number of factions or n number of areas in which these outfits have started, or they have already expanded their tentacles, and they are operating from there, and they are trying to eat the system from within. I mean, this is how we look at it. They don't allow any development to take place in the affected areas at all. I mean, this is what is actually happening.
So in short, you agree with the Supreme Court intervention. Mr. Desai
Absolutely.
thinks that, yeah, and Mr. Desai who has appeared for Saibaba in the past in one matter, thinks that the Supreme Court could have issued notice, but to stay the release per se, he doesn't agree with. Before I come to Shashank and Will Matthews, I just want to bring in Chitranshul. Urban Naxals, a phrase used in primetime TV studios of a certain leaning, has now entered the courtroom. The Solicitor General spoke about urban Naxals. He was referencing G N Saibaba, who is, after all, or was till he lost his job, a Delhi University professor. How do you see what's happened in court today, and the fact that an emergency meeting of the Supreme Court was called after Justice Chandrachud, who will be the next Chief Justice, actually said we'll hear the case on Monday? He was in no hurry. Then we suddenly found that there was an emergency sitting. So this was another curious dimension to what happened. Chitranshul, go ahead.
Yeah, see, Justice Chandrachud not only said that you should come on Monday, Justice Chandrachud also said that even if you come on Monday, I may not be inclined to stay the acquittal. That is what he had very clearly stated. Justice Chanchur and Justice Kohli's bench had clearly stated that. Now, on the question of, I just want to get back to Justice Shah's comment on the brain being the most important part of the thing. Now, Justice Shah, to his defense, he immediately clarified that he's not talking about this present case. He's just talking generally. It is an unfortunate comment, but he did clarify that. So, for a change, I am coming to a defense of the court in this situation. And as far as the question of this urgent hearing and listing is concerned, the center was given the liberty to approach the court for filing an early hearing application. But I somewhat was surprised to see that a matter is listed on a Saturday instead of a Monday. It was just a matter of 2 days. And a special bench was created to just hear this. This is again an appeal against an acquittal. And it was somewhat surprising for me, at least, to see such a quick hearing being granted in this
What
case.
did you make of the rush to hold the hearing?
The rush to hold the hearing was because the state's actions were criticized by the High Court. It's very clear that the High Court has said that the state did not apply its mind while granting its sanction. And the question of sanction, at least as far as in my opinion, is not a mere technicality. It is a very important procedure to be followed, and application of mind is important there because it's a question of someone's liberty to be taken away. So it is an important aspect of prosecution under UAP and cannot be dealt with simply saying it's just a mere technicality.
So this is in fact the hub of the debate, Chitranshul, that Devendra Fadnavis, who's of course the senior leader of the BJP, he reacted to the Supreme Court judgment and he used exactly this word, technicality. Let's just listen in to what he said.
आज सुप्रीम कोर्ट ने बॉम्बे हाई कोर्ट के नागपुर बेंच के उस निर्णय को स्थगित कर दिया, सस्पेंड कर दिया, जिसमें माओवादियों से संबंध रखने वाले, उनको मदद करने वाले प्रोफेसर साई बाबा को एक्विट किया गया था। मैंने कल भी इस बात पर बहुत निराशा जताई थी कि टेक्निकल ग्राउंड्स पर इस प्रकार से समाज और देश विरोधी कार्रवाई करने वाले को छोड़ा जाना ये बहुत ही दुर्दैवी था। लेकिन इस बात का मुझे बहुत समाधान है कि सुप्रीम कोर्ट ने हमारी बात सुनी, आज उस हाईकोर्ट के निर्णय को सस्पेंड किया। आगे एक कानूनी लड़ाई होगी, उसमें हम सारी बातें सुप्रीम कोर्ट के सामने लाएंगे।
That is the Deputy Chief Minister of Maharashtra, Devendra Fadnavis there, Shashank. If I can bring you in now, the point is that this has now become such a polarizing conversation that people, depending on their ideologies, are either backing Sai Baba as innocent or opposing him as a dreaded Maoist. Now, how do you see what has happened in the Supreme Court today?
Barkha ji, I guess Namaste Barkha ji and all other fellow panelists. Barkha ji, I guess I will have 3 pointers here. One, why this matter was heard on a Saturday. This is the first point which has been raised by fellow panelists. I guess when something is with regards to your sovereignty, your integrity, as in the country I'm talking about, I guess then that case will be preferred by the guardian of the Constitution, that is Supreme Court of India. And that is probably why Supreme Court listed this matter on Saturday. Now, point number 2, whether in this case there should have been a stay or whether the sanctioning power of the government should have been used in a systematic way. I guess 2 issues which Supreme Court today raised was, first, whether High Court justified in discharging merely on grounds of irregular sanction, and issue number 2 was that whether High Court was justified when non-sanction was not raised at trial. So the problem is when someone says that non-sanctioning is or sanctioning, irregular sanctioning is a very important structure, but judiciary is one of the most criticized a system in this country, or for that one institution in this country, because of our lethargic attitude, because so many cases are pending. So in a case like this, when trial court actually went into deep to say that no, these guys are anti-national and they have done so much against this country, mens rea, actus rea, both are involved and they are found guilty, and High Court merely says that no, because there is a technical glitch, they will be free from jail. I guess we need to be a bit sensible, or for that point.
So what you're saying
is,
what you're saying, Shashank, is that the conviction is on such a serious charge, which is effectively waging war against India, that an urgency has to have been shown. Mr. Matthews, as someone who has defended Siddiq Kapan, who is yet to actually walk out of jail, how do you see this? Because we also have the UAPA data before us. The charges against UAPA have significantly gone up, but the convictions don't actually coincide with the trend of the charges. So we saw a 72% increase in UAPA cases from 2015 to 2019. This is Parliament. This is in response to a Parliament question. And then, of course, there's the PUCL report that actually says there are many more effective convictions under the IPC than the UAPA. There you can see those figures. It's almost half. Mr. Matthews, your comments.
Well, first I have to say that I'm totally independent and impartial on this point. Well, basically, it is an issue of Article 21, that is right to life. That is right to life of the accused and the state on the other side. So Article 21 in clear terms say that is, no person shall be deprived of his life or liberty except according to the procedure established by law. In this case, what I see is the sanction for prosecution, that is a procedure established by law that should be followed without any doubts. I'm not talking about this case, in all cases, because that is a basic fundamental right. That is Article 21, that is a superior right. Because there are so many judgments that say that the Article 21 right to life is, even if there is no fundamental right, that right is there.
So do you believe that was followed here?
No, about that, my feeling is this. When it comes to listing of the matter before the Honorable Supreme Court today, we cannot see it in the negative aspect. Rather, it is a welcome suggestion, and it is my view that on every Saturday, cases like this should be heard because of the pendency of the case. If there is anything that is damaging India, that is the delay in the administration of justice. For that, getting the matter listed on Saturday, it is nothing wrong in with that. Of course, It was a rare case that I accept that, not doubt at all. But the point is this: the High Court, the judgment of the order of the High Court was stayed by the Honorable Supreme Court, but to the extent of on the ground that because sanction for prosecution is not taken because there is an issue that seriously affect the life of the state because of act of terrorism and rest of the things. There is Article 142.
So do you agree? Let's try and simplify this for an average person who's not a lawyer. Yeah. What I'm unable to understand is you think that it is correct that the Supreme Court held this emergency session. In fact, the Supreme Court should hold emergency sessions every Saturday in exactly this manner. And the stakes are high enough in this case. So let me go to Mr. Mihir Desai now. Mr. Desai, we have the unfortunate death. No matter which side you are on that case of Father Stan Swami, the fact is that he did die, waiting for bail. He kept saying he's not well. And there is now the lawyers making a big case about Saibaba that he's 90% disabled. He's in a wheelchair. Do you think that should impact the case?
Let me put it this way. I'll again start with a confession. I was appearing throughout for Stan Swami. So again, the whole issue of bias comes in. But let me put it this way. Look at Saibaba. He's 90% disabled. Okay, it's not just the fact that he's on a wheelchair. Wheelchair is only one minor aspect of his disability. Okay, his spine is not functioning. He has got liver problem, kidney problem. You name it, he has it. He can't even go to the toilet on his own. What is the purpose being served by the Supreme Court by keeping him inside the jail? One of the co-accused already died a few months back. Okay, so as I said, that it's one thing to issue notice, but after there being an acquittal or a discharge by the Supreme Court or by the High Court, there was no justification, as far as I can see, of the Supreme Court insisting that he should spend still further more time in jail when he could have been. He's not a flight risk anyway. So I don't.
Mr. Desai, since you did appear for Father Stan Swami, and if we can play those pictures now to remind our audience of that case, the same argument, you would know this because you would have made it, was made in his case. Banners off, please. And that was that he was too elderly to be of risk. And in this case, it's a similar argument being made given the 90% disability of Professor Saibaba. So I just want you to elaborate on that.
See, the point is this, that ultimately, if you look at our prisons in India today, the conditions of prisons are pathetic. Okay? The health facilities are pathetic. I mean, they are very bad. And I've been appearing in various public interest litigations concerning prison conditions. I know, I've visited prisons. I know what the conditions of prisons are. They are pathetic. Even a very healthy man will go inside and become ill. And you have a situation where you have this kind of extremely ill people, okay, who are put behind bars, who can very well be controlled, even assuming that they are the brain or they are the brawn or whatever it is. Even assuming all that, they can be controlled very well, even if they are outside. Okay, like Mr. Basant, who was appearing for Mr. Saibaba, argued, let him. I mean, let him not get out of his house. You cut his telephone if you want to, but don't make him suffer any further. Because this is, I mean, imprisonment itself is a punishment. You can't have a double punishment by making his life even worse.
Yeah, let me take this to Mr. Yeah, got it. Mr. P.K. Jain, when this argument was made by Sai Baba's lawyers, and Mr. Desai represented Stan Swami, a similar argument was made in his case, and he died in custody waiting for bail. Do you not think there should be some application of what's the word I want to use? Assessment on a case-by-case basis, that if this person is not a flight risk, if this person cannot inflict harm, then why keep this person inside prison? To which, of course, the Solicitor General didn't agree. He said there's a tendency among urban Naxals to seek house arrest over jail. Mr. Jain?
See, Barkha, as I said, I do not buy this argument. These are all misplaced sympathies. These people have caused enough damage in the system. They have caused the deaths of hundreds and thousands of people, be it the villagers, be it the people who have opposed them in the field, and be it the security forces. So if a person has done any of these acts, he has done with the clear knowledge of the consequences that he's going to face. So any disability on their part does not call for any justification or any sympathy, misplaced sympathy, to grant them any kind of relief. They must face the consequences of their actions, be it in jail or outside. Now, coming to the part of his release from the prison, or why should the Supreme Court take the hearing on a Saturday and all that, one forgets that the Supreme Court had also given a hearing to Tiger Memon in the night. They had also given a hearing to Kasab in the night. So when all the human rights and all the hullabaloo about the human rights is only for the accused, for the people who have killed hundreds of people, and there's no sympathy for the victims. We have in this country, we've always we have never stood for the victims' rights. All those people whose hands and legs have been chopped off in the jungles just because they went and were the so-called informers of the police or of the system. One does not even think about them. One does not even keep them in their imagination when they talk of these things. So I am not in favor of any kind of misplaced sympathies. The people have to pay in whatever condition they are. The system is what it is. Now, Mr. Desai has himself stated that he has been fighting for the betterment of the conditions in prison. I'm 100% in with him for this, that the conditions in the prisons must be improved. The medical system, the medical attendance system in the prison must improve. But that does not justify for any person to be released on the basis of his physical condition or his physical inability or disabilities.
Can I get, thank you, Mr. Jain. Can I get Chitranshul to respond to this? 2 points there. One, that age, disability does not actually alter, the appraisal of a court or of a law enforcing agency. Two, that rights activists do not wonder or speculate over courts opening at midnight when there is a hearing for someone that they are ideologically sympathetic to. Chitranshul, how would you respond to that?
Yeah, as far as the hearings with of Memon or Kasab are concerned, there were hearings in death penalty cases. There were cases where they were bound to be hanged till death till the very next morning. So there was a necessity of having a night hearing or an urgent hearing in that situation. In this situation, say appeal against acquittal. Mr. Jain is shaking his head, but at the outset, I must say nobody here, at least I am not here sympathizing with Maoists or criminals in this country. I'm only talking about the procedure in this case. And the procedure, and why I say so is that an appeal against acquittal, when the person is in jail, even after the judgment yesterday, he was not released. He was still in prison, and there was no chance of him being released even by Monday. I did not anticipate him being released even till Monday. So hearing could have been taken.
And can I get Mr. Jain to briefly? I think he wants to interject there, and then I'll let you complete your point. Mr. Jain, go ahead.
Sure.
Mr. Jain, 1 second.
Supreme Court
yeah, go ahead. Yeah.
Let the Supreme Court take its own decisions whether they want to hear the case on Saturday or Sunday or Monday. So how does it make a difference? Why should we make an issue out of it? The matter was to be heard by the Supreme Court. It has been heard by the Supreme Court, whether they have granted a relief or not. And let me be very clear about it. The trial court has gone into the merits of the case. The defense at that time did not raise the objection regarding the sanction part of it. The High Court has interjected and they've simply discharged the accused on the basis of a non-grant of sanction. Now, the Supreme Court has overturned or stayed that decision. What is wrong in that? I mean, it is something which is a mere technicality, both on the part of the High Court as well as on the part of the Supreme Court.
Okay.
The Supreme Court is yet to hear the case in detail and then pronounce a judgment.
That's right. To what has happened today, I just want to make it clear, is of course not a judgment. The walking out from jail of Professor Saibaba has been stayed. It doesn't mean that this is any kind of ascertaining of guilt or innocence at this point, just to be technically correct. Chitranshul, on the age and disability argument, if you want to just come in at this point on that. Chitranshul? Hang on, I'll just unmute you. Just give me a second. Yeah, go ahead. Yeah.
My point that...
Hang on. Yeah. Go ahead now. Yeah.
So I was just finishing my point, saying that it's the Supreme Court's prerogative and decision and discretion to hear a matter on a Saturday or Sunday. Whenever that is the Supreme Court's discretion, they've exercised it. That's well and good. And as far as the question of technicalities, etc., is concerned, the important point here is being missed. The point here is not what the trial court has said after that. The jurisdiction of the trial court to entertain any particular matter is an inherent question of law. It is the court's duty to determine whether it has jurisdiction or not, and it can be taken up at an appellate stage as well. And that is what the High Court here has done, said that because they did not have jurisdiction, that's why this conviction cannot be upheld. So that is a very important point. The question of jurisdiction is very important.
Yeah. Shashank and Mr. Matthew, Shashank Jha, please go ahead. Give me a second. Just give me a second, sir. Give me a second. Sorry about this today. You're muted at your end, sir.
Please. Really, the sanction for prosecution.
Yeah, Mr. Matthews, you can take that. Will Mr. Jha unmute himself? Yeah, go.
Yeah, kindly grant me 60 seconds, and I will explain a few things.
Mr. Jha, go ahead. Yes.
Thank you so much. So when we are saying that the Act UAPA is draconian, and the increase in 72% in past 5 years, I guess we also need to compliment the government of the day, which has actually reduced Naxal attacks in most of the states in this country, including Chhattisgarh, Odisha, Jharkhand, Arunachal, Andhra Pradesh, etc. Point number 2, when we say that Article 21 is very important, we also need to understand that Article 21 is part of Constitution of India, which came in 1950. However, India got independence in 1947. That means sovereignty is more important than democracy. We need to have sovereignty in order to protect the democracy. When you are saying that
why does it have to be either or? Why does it have to be either or? You can have sovereignty of the state well within the framework of a strong, robust democracy, right, Mr. Jha?
No, yeah. So that is why Article 21 says that state has the duty to protect the interest of this country, and that is why they say that as per the law and order of the state. Now, what I wanted to make through my submissions was, when someone says that 90% disability cannot do anything, I will just give you an example of Stephen Hawking. Now, he was more disabled than Sai Baba here. He actually found a black hole for this world. And now, so with mind and without any physical capability, you can do much. So be it finding black hole or doing Naxal attacks, you can use your mind.
Let me get Mihir Desai to come in briefly on that, because Mihir, you made a passionate argument about disability and age being relevant factors. Shashank is invoking Stephen Hawking. Yes.
Yeah, let me say one thing, that I never said that Sai Baba cannot do anything. I didn't say he's a vegetable. But I said that whatever you need, you can prevent him from doing. Suppose you feel that he is going to assist the Naxalite activity, you can prevent him from doing that. Okay, you can cut off his phone. You can say that he will be in the house and he will not get out of the house. So there is an easy way of preventing that. Just as if Stephen Hawking had not been given his physics books and all that, he would never have found his black hole. Okay. Similarly, Sai Baba would not be able to do it, assuming his is guilty. The second thing I just want to quickly point out here is that just as I don't have any sympathies for Naxals who commit violence, I do not have any sympathies for police who regularly beat up people in the jail. And remember one thing, that Maharashtra has the highest rate of custodial deaths in this country. So let's not just think that only one side is all dirty and the second side is clean. Let's be very clear about that.
That's a fair point. Of course, I don't think anybody on this panel is defending extrajudicial violence. I was actually going to go to Wills Matthew, but I'm sure PK Jain wants to intervene there. Go ahead. Mr. Jain, go ahead. Hang on, sir. Let me just... Yeah, go ahead, sir. Yeah.
Barkha, the number of custodial deaths in Maharashtra is very high because we take every death in and around a police station as custodial death. Even if a person has been called for inquiry, a witness has come to the police station, and if he dies in the precincts of the police station, we register a death in custody case, and it is immediately transferred to CID. So therefore, the number of deaths in police custody, not because actually there are deaths in police custody, any death, even if the guy is sitting on the wall of the police station and coming as a witness, I'm telling you, Mr. Desai, please don't react like this. I'm telling you a fact. I have been facing my officers who had nothing to do with custodial deaths. Have faced death rap.
Cases of custodial deaths. I know what.
No, I see the custodial deaths. You
10 cases of custodial deaths. One happened just about 20 days back. Please.
No, I am not denying. I am not.
Police being all clean.
I am not denying.
All very wonderful and police.
Okay.
I am not denying.
Okay,
Mr. Desai, I am not denying deaths in police custody. I am not denying the people getting fixed or people still beating up the accused or the suspects. But what I am saying is the number of deaths in police custody in Maharashtra are high because of this reason also. And number of cases are getting registered.
Let's come to the operative argument that Mihir Desai actually made. We can have a separate program on custodial violence. Right now, the point that's being made, Wills Matthew, you were waiting to speak, is that there is a way to contain the activities of Professor Saibaba. Don't have internet access, let him be at home with his family, cut his phone lines. I'm just quoting Mihir Desai here. If there is a suspicion that of continued engagement with Maoist groups, why keep him in prison? Factor in his disability while you take a decision. What would you say to that, Wills Matthew?
Well, with respect to brain can be, because ultimately what matters is the brain, no doubt at all. So I'm not on that point. I'm only on the point of sanction for prosecution. That is a very valid ground for not to continue with the proceedings. But when it comes to, even if a person is slightly, because he can think and act, ultimately it is that brain that is the motivator for all these actions. No doubt at all. I'm not against that. But this sanction for prosecution is an issue that go to the root of the subject matter. Without sanction, any kind of proceedings initiated against the concerned person, that was illegal. That is my view.
Okay. I need to take quick closing comments. Shashank, briefly. Yeah, Shashank, we'll start with you, Shashank.
Yeah, so I guess this point could have been taken had they been raised during trial. They did not. Trial took its own time to decide whether they are convicted or not on all the aspects, cross-examination, etc., etc. After that, only they convicted these accused. Now, raising those issues which has not been raised during trial merely on the ground of technicalities, I guess we are derailing the justice system, which is already slow in this country and being criticized time and again. This time we should come together to defend our country and not urban Naxals like Solicitor General stated.
Okay, Chitranshul, I'll give you a quick closing comment. We do have to close then. Custodial violence takes us into a different direction. Mihir Desai is making that point, a separate program for that. But I want to come back to disability and age and whether they should be factors at all.
Yeah, see, unfortunately, the UAPA has that does not allow you to get bail on any ground unless and until it's a medical reason. Unfortunately, the Vatali judgment also emphasizes on that getting bail under, especially when you're accused of charges of terrorism, it's almost impossible to get bail under UAPA. The only ground that remains is medical reasons or disabilities. So to that extent, Mr. Desai's point is very fair. That if a person is disabled, let him stay outside the jail. That is the only exception, in fact. There is nothing else.
Well, I think we'll have to close with saying that the last word on this has not been spoken. Even the Supreme Court's decision today is probably the beginning and not the end of where this case will eventually end. Whether sanction for the prosecution was given per procedure or not, the Supreme Court has held is not basis enough to discharge G N Saibaba. So the Supreme Court will now pretty much have to decide the merits of this case, as I understand it. We'll have to leave it there. Chitranshul, Will Matthew, PK Jain, Shashank Jha, and Mihir Desai. Thank you to our audience. Have a great weekend and see you soon. Take care. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.